Hey there.
Hey, good morning.
Good morning. I'm about to let the other folks in. It looks like there are lawyers. I can't get it to scroll quite right, but several lawyers. I'll let them in and we'll take it from there. Anything that has been late developing that I need to know before we start?
Yes, it looks like one of the lawyers, Mark Molina, just sent over an exhibit, and I just forwarded you that.
Okay, I saw that. Let me open it up
Okay.
and we'll see. So he's got the car full of Morgans. Well, that's kind of actually helpful. All right. It'd be interesting to see how people suggest one divides it up,
Right, it really will.
but we'll figure it out. All right. Thanks. I'll let everyone in.
Okay, great.
Good morning, everyone.
Good morning.
Morning.
Letting folks in here and we'll figure out what's going on.
Okay, perfect.
All right. I'm Judge McBurney, just changed the name so it shows you who I am. Good morning to everyone. This is Civil Action 2019 CV324001. It is an interpleader matter brought by Owners Insurance. And I'm going to figure out who all we've got on this call. I recognize most of the names. There's one that I don't, but I'm sure folks will explain who they're connected with. So I'll start in the upper corner. Mr. Molina, good morning.
Good morning, Your Honor. Thank you for setting this up. I represent with Rory Chumley, Johnny Morgan, Shabrion Smith, Jameer Colquitt, Jason Colquitt, and Sakia Colquitt.
Okay, and they were all passenger. Well, Mr. Morgan was driving the vehicle, and then Miss Smith and her kids were passengers in his car?
That is correct, Your Honor. Thank you.
All right, Mr. Molina represents them. I'm next. Hey, Judge McBurney. Mr. Fernandez.
Yes, Your Honor. I'm representing Chantel Horace, who I believe, according to the police report, would be vehicle number 4.
Yeah, actually, she did not get struck based on my understanding by the vehicle. Mr. Friesen on his rampage, whatever was going on, hit a pole and the pole hit Ms. Horace. So he's clearly at fault. But as I understand it, his vehicle didn't hit hers, but collateral damage from whatever was going on Capitol Avenue caused damage to Ms. Horace's vehicle and maybe to herself. I see Mr. Brichardi. How are you, sir?
I am doing well, Your Honor. Thank you.
Thank you for dialing in. And you are here on behalf of yourself and then your daughter, Sophia?
Correct.
Okay. And then we have Ms. Portavant. Good morning.
Good morning.
You are here on behalf of?
Plaintiff and Interpleader auto owners.
Great. And then Ms. Niles is my staff attorney. She's going to just listen quietly and help me with anything that's too difficult. And then we have Mr. Van Sant. You represent Ms. Hood?
Yes, that is correct.
Great. That covers everyone. Well, couple things. We are doing this virtually, so it's a little more difficult for me to see exactly what's going on. If folks have a concern about something that I say or someone else says, don't worry. I'll make sure before we're done today that everyone has had a chance to, 1, state their case, and 2, respond to what they hear from other folks. It's just the ebb and flow of communications will be a little different than we might experience if we were in court. Second thing, this is being live streamed, so I don't know if your clients are interested in watching. They might have come to court, they might not. They probably prefer to be elsewhere. But it is live on YouTube, so that if they want to participate as a listener or viewer or both, they're free to do so. That link is on our court's website. It's pretty easy to find. But that's a way to make this publicly accessible. I try to limit the Zoom to the lawyers or self-represented parties like Mr. Burchardi. But for other folks who have an interest in this, they are more than welcome to watch and listen, but that would be through the YouTube channel. So let me set the stage as for what I understand is happening here. Mr. Friesen, in April of last year, was driving on Capitol Avenue, and don't know what happened. He'd have to tell us, but it didn't go well. He strikes Mr. Morgan's vehicle from behind. In Mr. Morgan's vehicle is obviously Mr. Morgan, Ms. Smith, and her 2 children. He then hits Mr. Burchardi's vehicle. He's driving it. Mr. Burchardi is. His daughter, Sophia, is in the Burchardi vehicle. He then, Mr. Friesen, hits a pole that falls over and strikes Ms. Horace's vehicle. And finally, not quite done, Mr. Friesen hits Ms. Hood's vehicle. And by then, I guess it's out of gas or the wheels have come off, but he doesn't hit anything more after that. The coverage that seems to be available, although I read in one of the answers a demand for an affidavit from either Mr. Friesen or from Owner's Insurance that really this is the only pot of money that's out there, the $50,000. But as I understand it, the coverage is $50,000, and that has been deposited into the registry of the court. And so my role, upon input from you all, is to figure out the most equitable way to apportion the $50,000. Mr. Molina submitted an exhibit that I only received this morning that seems to suggest that there is more demand than there is supply. In other words, each of the parties is able to document a loss that, if you add them together, is more than 50,000. So unfortunately, I don't have the luxury of saying, let's give Mr. Morgan everything he needs, let's give Ms. Hood everything she needs, and there'll be money left over. It sounds like we will be giving people a proportionate share of what their medical bills and or lost wages have been. But we'll work through that. I'm going to start with Ms. Portavant. I don't know that you're going to have a big role in this. Your firm, your client, has put up the money that it needs to put up, and it's not your job or your client's job to figure out how it gets allocated. You were doing the appropriate thing on behalf of Owner's Insurance. But is there anything you want to add to what I've just shared?
Judge, no, there's nothing further I would add. I did have a discussion with the claimant's attorneys about reaching Mr. Friesen to see if I could get an affidavit from him. Of course, I don't represent him, but we tried. We're not able to get in touch with him. So we have put the $50,000 that we know of for certain on behalf of auto owners into the court's registry.
Okay. Well, we know we need to start with that, and it may be that one or more of the claimants is able to unearth additional coverage, and we might have Interpleader Part 2. That would be a related case. It would come back to me, and we'll deal with it in due course. But to Ms. Portavant's point, Friesen is not her client, and her inability to get an affidavit, I don't think stymies us at this point. There is $50,000 that needs to be allocated, and I think we ought to focus on that. But I'll certainly hear from each of the parties as we work through this if there's a differing perspective. And my thought was just to go through this chronologically, if you will. In other words, in order of which a vehicle was struck, and that everyone will get heard that way. That's not necessarily how we'll allocate it, so that if Mr. Morgan and his passengers use it all up, then everyone else is out of luck. I'll just hear from that party. And so we'll hear from Mr. Molina. I'll hear from Mr. Burchardi. then Mr. Fernandez, and then Mr. Van Zant about the best way to allocate the 50,000. So Mr. Molina, why don't you get us started?
Thank you, Your Honor. I will say, Your Honor, before we proceed, that we have had collectively calls, all the parties, giving your instruction when we were last at court. There have been emails, we had conference calls, and everyone has been working together collectively, amicably. So
Fantastic.
there hasn't been any animosity whatsoever.
So then maybe your exhibit is reflective of that collaboration, and those numbers aren't going to be particularly controversial.
That is correct. That is my hope. And Your Honor, I will add that depending on what Mr. Fernandez puts on the record relative to his what he's seeking on behalf of his client, I have addressed both of those scenarios in the numbers. But to the extent that we all collectively almost immediately agreed on a conference call that Mr. Bacardi's request for the $500 for his settlement, regardless of his status as a non-answering pro se defendant, seemed completely reasonable. And we all, subject to court approval, said that was fine with us. Of course, subject to Your Honor's approval.
Okay.
So that being said, and if the court does approve that, we take that 500 off the top, and then the collective respective percentages are on my one-page submission, and I'm presuming that
I have a 5-page submission from you. I'll pretend it's 1 page, but
sorry. And what I didn't want to do, Your Honor, I know that Parker Van Sant sent you all of the specials for Ms. Hood. I did not want to, I mean, of course, if you tell me you want that, Your Honor, I will, but I did not think such was appropriate. It would be an email of massive proportions.
sure.
So at this point, I'm going to presume that Mr. Fernandez is going to forego any allocation of these liability funds. If that is true, subject to Mr. Fernandez confirming that, then I would submit to the court that the court distribute the funds pursuant to the numbers that I submitted. And my further request, Your Honor, would be that if the court does that, I and Mr. Chumley be able to further allocate, so as to each particular plaintiff. So my request would be that the court distribute to us $33,809.
Sure. And then you subdivide that as you see, as you and your various clients have agreed.
Yes,
Okay.
that way I can, Rory and I can attack each UIM carrier depending on what the client's needs are. So that's it for me, Your Honor. If I'm fortunate enough that Mr. Van Sant, who, like I said, all of us have been working very amicably, I had asked if he would consider not taking any of the pie. He had refused that, and that's fine. It was completely fine. Then the percentages are reflected in my request in my 5-page submission, Your Honor. I don't have
Okay.
anything else to add at this time, Your Honor. Do you have any questions for me?
I do. I'm trying, the one thing I'm looking over your exhibit. Does everyone have a copy of that? You don't need to be looking at it collectively now, but Mr. Molina has a 5-page PDF that is entitled Revised Numbers If Chantal Horace Pursues UM Only. Has everyone seen that? Just raise your hand if you've seen it. Great. And Mr. Van Sant, is that a hand raise?
Yes.
Okay,
Great.
great.
Thank you.
So what I was trying to sort out while you were sharing this with me, Mr. Molina, is where the 46,881.95 comes from, because that's
Judge,
you're
I
using
did-
that as a percentage of. So just using Mr. Morgan as an example, you've documented that you believe he's entitled to 9,800 plus some change, which is a certain percentage of 46,881.95. Where does the 46,881.95 come from?
You know what, Judge? When I did the percentages, I might have messed up because I did one number with the wage loss and another number without the wage loss. So to the extent, if the court through Ms. Niles wants to adjust those numbers, I may have made a mistake in that percentage.
Okay.
So I guess the percentages, we would start with the 49.5 and adjust
Right.
accordingly.
Yep.
I think those would be a couple of decimal points in either direction, and I apologize for that.
That's okay. It may be that the math works out anyway. I
Okay,
just
great.
wasn't sure of the origin of that figure, but let me work my way down the chain of events. So Mr. Burchardi, you would be next. It sounds like your request is 500 and Mr. Molina has no objection to you getting the 500 so that then the remaining parties are divvying up the 49,500. Is that a fair statement?
Yes, Your Honor.
Okay. And the way that would work, if in the end that's what my order reflects, is that a check would be sent to an address of record via certified mail. So we just need to make sure that we've got a good address for you. The check would be in your name, not in your daughter's name. I trust you'll get her what she needs. But that's how we would handle the distribution of the $500. Does that make sense?
Yes, okay.
Okay, any questions or concerns about that?
No.
All right. Mr. Fernandez, you represent Ms. Horace. The suspense is built. What is the game plan for Ms. Horace? What are you planning on doing?
Yes, Ryan, good morning. I think that given the limited pool of available liability info, money, what we're going to do is forego any claim to the liability money, but we want to be sure, and then we're going to proceed against the UM for the entirety of the claim. We
Sure.
do want to confirm, or at least, Ms. Horace wants to ensure that and I don't think either of these conditions will be an issue, that all the liability funds are expended, so we can go ahead and present a UM claim since there is no other insurance, and then that the order reflects that we can do that. And that's pretty much it that we need. I mean, we'll just go against the UM. I mean, and we're
So
okay.
if you would, I don't have an issue with that, and we'll make sure no one else does. If you could email to Ms. Niles the language that you'd like to see in the order that protects your client's interests. It's a very reasonable request. And I'm happy to accommodate. I don't want to draft the language if it is insufficient. I wouldn't want to undercut your ability to pursue the UM claim because we messed up the language.
Absolutely,
Okay.
but that's it. I mean, no objection for Mr. Picardi on the 500. I mean, that's completely fine.
Okay. Well, let's turn then to Ms. Hood, Mr. Van Sant. As I understand it through the ratios here, Ms. Hood would get a significant piece of this as well. It may not cover everything that needed to be covered, but she would be entitled to her proportionate share. Are you comfortable with the way those numbers came out, or where are you right now?
I mean, to be honest with you, Your Honor, I would prefer my client to receive more money than what's being allocated in this situation. My client suffered from a traumatic brain injury following this wreck. We submitted to the court all of her medical records, bills, and all supporting documentation and information to support that claim. To Mr. Molina's point, he's presented only numbers. He hasn't presented any evidence or shown anything to the contrary to show that his claim to that money, the lion's share of that money, is supported. And to me, I have a really big problem for my client, and justice for my client, her receiving just the cover of her medical bills in this situation when her brain injury following this wreck was very traumatic for her. And we submitted the information and documentation to support that. And, for Mr. Molina's clients, he's asking for the vast majority of this money, but I haven't seen any documentation or any information to support that his clients were as injured as they're claiming.
So a couple questions. First one is just numbers. My review and Ms. Niles's review of the file showed documentation of 13,000 plus change in medical bills for
Yes.
your client. That is it's a meaningful sum, but it is only a fraction of the 50,000. What am I missing? Because what I'm hearing you say right now is these big numbers, and we've put all sorts of paper behind it. And yet when we were preparing for this call, the only number we were able to hang on anything was the medical bills for Ms. Hood. Everyone else was a bodily injury claim with no numbers attached. But I remembered that I had asked you all to confer and see what you could come up with, which I thought was what Mr. Molina just shared. So let's start with what is it you're describing when you say there's documentation of Ms. Hood's damages?
Well, we submitted all of her medical records and bills, photos of the damage to her vehicle, and based on that information, I believe that she should be awarded more than just what her medical bills are. That's just our position in this matter.
How do you put a number? More is better for Ms. Hood, but more is amorphous. The medical bills are specific, and it's easy to tote those up and say certainly those need to be covered by the insurance money. Have you put numbers around these other figures, or it's simply more is better?
No, I mean, what me and Ms. Hood had discussed was we felt as though $25,000, basically that'd be $11,927.05 for pain, suffering, and inconvenience for what she's had to go through with this traumatic brain injury following this wreck. We felt as though that would be an appropriate amount given the circumstances that she's gone through. And we understand that the other parties involved, they do have, other avenues of pursuing additional compensation for this. We discussed that and the possibility of that being an issue. We've all done that, and that is obviously a possibility for everybody involved. So, with that being said, when I had a conversation with Ms. Hood about this, we felt as though $25,000 for her injuries would be appropriate, and that's what we're asking.
So then that gets to my second question, which is walk me through where things fell apart, because Mr. Molina started us off by saying, actually, we've been on the phone a lot. We've had conference calls.
No, I wouldn't say anything's fallen apart necessarily. I'm just saying Mr. Molina has, at the beginning, Mr. Molina wanted all the money for his 5 clients. And I was like, that's not going to happen. I mean, that's just not going to happen. And so he's like, all right, well, let's try to give her that money and have it, Enrique's client get nothing. And I'm like, all right, I don't really care how the money for everybody else is distributed. I just want to make sure that Ms. Hood is properly taken care of. I think that, Mr. Molina's suggestion, that Ms. Hood's medical bills at the very least get paid is a good starting point. But I also have to look out for the best interest of my client as well. And I'm pursuing additional funds. I mean, and that, from my understanding, that position was just brought about this morning from Mr. Molina.
What position?
That my client received $13,000.
That's the first you heard of it, that would be how this sorts out. Prior to today, your position as expressed to everyone else was that she should get at least half of the money?
No, not the case. No, that I have not necessarily expressed that, but I have been pushing for more money than what they're offering originally. That's why we're here today.
Okay.
So, and I mean, ultimately it's up to the court to decide, but that's, the conversation I had with Ms. Hood, and that's, I wasn't able to speak with her last week, and I was able to talk to her this morning. So that's, the conversation I had with her, and that's, what we felt would be best to pursue in this matter.
Okay. Mr. Molina, I'm going to bounce back to you.
Yes, Your Honor.
I am looking at your exhibit that you shared with us this morning, and there are some fairly specific numbers for each of your clients. I'll just take one. Jameer Colquitt, $4,076.25.
That's correct.
What does that represent?
ER and some limited treatment.
Okay.
And, Your Honor, may I address one topic that Mr. Parker brought up?
In a second, I'm gonna
Sorry.
let you do that. So the figures that are on your exhibit for each of the 5 passengers in Mr. Morgan's car, including Mr. Morgan, those are, I guess it says it at the top, bills incurred by all plaintiffs. So
That is
those are bills. There's documentation to support that. It is not pain and suffering.
not pain and suffering, hard medical specials, Your Honor.
Okay, so no one, setting aside Mr., I don't want to mispronounce it. Is it Burkhardy or Burchardy?
Riccardi.
Okay, setting aside Mr. Burkhardy, where it's just the round $500, for none of the Morgan passengers, and for not for Ms. Hood either, in the way this has been sorted out, is there any award for pain and suffering? It's all for bills.
Correct.
Okay. If we're going to provide for pain and suffering for one, we really ought to provide for pain and suffering for all. It would be fractional, but that would just mean then some bills don't get paid, and I guess the money would just get diverted to paying the bills. But what did you want to add, Mr. Molina?
That I did suggest that everyone, as Mr. Parker Van Sant has indicated, all of us have UIM avenues, which is why I only submitted hard medical specials, so that everyone is entitled or can go via the specific UIM scenarios. So when I suggested to Parker Van Sant that he get nothing, it wasn't that he not get anything, 0 for his client, of course not. I had suggested that if he were not to get any liability funds, he would be able to proceed against his UIM carrier solely without having to explain to the UIM carrier, I received X from the court and now I want Y from you all. I had suggested that it would be better, in my opinion, I could be wrong, that he could go solely against the UIM carrier and say, I received nothing from the liability carrier. And that way he'd only have one targeted entity for recovery.
Sure, like Mr. Fernandez is doing on behalf of
That
Ms.
is
Horace.
correct, Your Honor.
One more question for you, Mr. Molina.
Yes, Your Honor.
Mr. Van Sant has provided documentation for the medical bills for Ms. Hood. He suggested you hadn't. Is there a way, without much effort, you could make available to Mr. Van Sant some medical bills for the 5 Morgan passengers, so that he would have a comfort level that in the same way that you're comfortable, Ms. Hood toted up over 13,000 in medical bills. Your figure is much higher, but it represents 5 people.
That's correct, Your Honor.
But that might address at least one of the concerns. I
Not a
appreciate
problem.
everyone's interest in trying to get more for their clients. This was a real bad situation that happened, but with a limited pool of funds, it's not going to address everyone's needs completely.
I can do that, Your Honor. I can do that immediately after the call.
Okay. Well, let me go back then and see. Mr. Fernandez, I'm now doing a final round here. I don't think there's anything you need to add. You've explained your position on this, and I appreciate you plugging in and letting us know what the plan is. Mr. Van Sant, my thought is that I give Mr. Molina an opportunity to get to you the medical records for his clients, so that you can see those and at least have a comfort level of, well, all right, they had expenses also. And upon receipt of those, you could shoot an email to Ms. Niles saying, I got them. And they in fact support the figures that Mr. Molina set out in his worksheet that shows how we divide this up. I'm going to use the word equitably because it's driven by expenses only. It's not pain and suffering, but it's driven by expenses. And if you take it on a per individual basis, it looks like Ms. Hood actually gets the largest share. Mr. Molina's clients, that's plural, get a larger share, but none of them had the level of medical expenses that Ms. Hood did. So in one respect, she's getting the largest recovery from the limited pool of funds. None of it, I acknowledge that, would go to pain and suffering. But if we're going to open that up, I would think then that I ought to hear from everyone about what pain and suffering was for them. And we are getting into a complicated area when you've got kids and the pain and suffering of a mother with her children injured and this and that. And I don't know that that's really where you want to go. So what I'm going to propose is that we have Mr. Molina get to you documentation that would support the figures on his sheet that is titled Bills Incurred by All Plaintiffs. And if it supports that, then I think we have reached what I view as a reasonable way of allocating the limited funds that we have. Any response to that, Mr. Van Sant?
That's fine with me. I mean, I'm in agreement with that. To be perfectly frank, I believe that this information should have been presented when the court requested it to begin with. I mean, presenting exhibits by this date, I adhered to that. I presented the exhibits, and we're getting exhibits 10 minutes before the hearing. I think that the record should stand as it is, but that's my personal opinion. I'm more of a hardline person when it comes to deadlines and whatnot, but I would agree with your position, and I'll be more than happy to review those medical records and supporting documentation, and I'll email Ms. Niles once I've done so, and we'll be able to allocate the funds appropriately then.
Okay, well, I appreciate your perspective. Given the times we're operating in, I'm going to let Mr. Molina get that out. He said he could do it today. He'll need to do it today.
Absolutely.
And then you take the time you need, Mr. Van Sant, to look over the materials. But if they support the figures that have been discussed with the group, then I think what the order will look like, the final order in this case, will be 500 to Bricardi, and then the remainder of the funds on a pro rata basis driven by the medical expenses. And that will exhaust, unfortunately, the 50,000. I will need Mr. Fernandez to submit the language that he thinks will protect his client's interests. Get that to Ms. Niles. That will make clear in the order Ms. Horace is making no claim to these funds, but intends to go after the uninsured motorist opportunity. And I'll also need to make sure each of you gets to Ms. Niles the full name and address of where you want these funds sent. The clerk's office has asked me to discourage folks from coming in to pick up the check. That has always been an option. They're not wanting a whole lot of person-to-person contact right now. So each party needs to get to Ms. Niles. Here's the name and address. That the check should be made out to Van Sant and Associates, or whatever it would be, or care of, and sent to this address. And they'll send it certified mail upon my direction, but they'll need that information. So that's how I'd like to work it. Mr. Molina, you're committing to getting the bills, the documentation to Mr. Van Sant. Send it to everyone. Folks can throw it away if they don't want to read it, but I appreciate Mr. Van Sant's observation. And I think in normal times, I'd probably line up with him saying, you had a chance to get us these numbers. And while I trust you as an officer of the court, I trust even more that bill from Wellstar showing that it was $4,822 for JC on Colquitt. Mr. Fernandez, your only due out is to get the proposed language to Ms. Niles. Mr. Bricardi, you will get the address where you'd like the check sent. Ms. Portavant, I don't think you need to do anything, but if there's something you want to see in the order, get that proposed language to Ms. Niles. And then Mr. Van Sant, you need to let Ms. Niles know today, yes, I got the records and here's how much time I'd like to look them over. And then at that end of that deadline, just confirm that you're satisfied that they do sufficiently document the numbers that I was under the impression had been circulated. And if they do, I'll get the order out. If they don't, we may need to reconvene, although we'd probably do it with a subset. I don't think we need to bother Mr. Bacardi again. He's going to get that amount. We wouldn't need to bother Mr. Fernandez. He'll get the language he wants. And we would just work through what we're doing with the remainder. Mr. Molina, does that work for you?
Absolutely, Your Honor. Thank you for your time, and thank you for Ms. Niles for setting up the Zoom proceedings. I think it went pretty well.
Mr. Fernandez, that work for you?
Yes, Your Honor. Thank you.
Mr. Bacardi,
Yes, Your Honor.
your daughter doing okay?
Yes.
Awesome.
Good. Is she of school age?
Yes, she is 7 years old.
So she's having to do like this virtual school now?
Yes.
How's homeschooling going?
It's not what we signed up for.
No, same. I have a 3rd grader and a 7th grader. So when I'm not doing this, I'm running upstairs saying, do your math. It's a challenge. Ms. Portavant, anything else on behalf of Auto Owners Insurance?
No.
All right, thank
Thank you,
you
Judge.
for getting those funds into the registry. And last but not least, Mr. Van Sant, anything you want to add?
No, Your Honor. Thank you for meeting with us today, though.
Not a problem. It's what we need to do. I appreciate folks' flexibility with this format. I think we made some important progress here. And Ms. Niles will be looking for emails from each of you. And just to recap, Mr. Van Sant, you're going to take the time you need with the records. I won't get that order out until you've had a chance to look at them. So please do let Ms. Niles know. I have no idea if Mr. Molina is going to send you 80,000 pages. You may need a minute. It may have some nice summary pages on it from the hospitals and the medical providers that'll make it easier for you. But just keep us posted.
Will do. Thank you.
All right. Thank you, everyone.
Thank you all.
Thank you, Your Honor.
Ms. Niles, can you stay on, please?
Sure.
All right.
Bye-bye.
Bye.
Bye.
He's gone. All right. Happy Monday.
Thank you. Happy Monday to you.
So you did a great job with the white order. That was a messy one, and I was very impressed with what you did. I am having to change one part of it. It pains me, but I struggled in the same way that you did.
Okay.
And I'm not going to dismiss count 1.
I think that's totally fair.
Because if I did, we'd basically be saying, and you'll see this in the order, that the exception swallows the rule. As long as whatever the public agency is votes on it, then it was necessary. And then there's really no protection. They could do what DeKalb allegedly did in Williams, which was complete shenanigans. If what Williams said was true, and he deserves a chance to prove it, that was total shenanigans. We don't want anyone to know we're going to give ourselves a raise. Don't tell anyone. And then at the last minute, we'll add it and vote for it and be done with it so that no one could show up and protest.
Right.
I don't think that's what was going on with this Gulch thing, but the Gulch thing was a hot topic. And I know that if the anti-Gulch development people were aware that it was going to be on the city council's agenda, they at least would have been there in their red t-shirts that says stop the Gulch. They showed up in court for all our bond validations in that matter.
Right.
So I think in the end, White's going to lose because now it'll go away at summary judgment and the city will get affidavits saying it was necessary. And there's no definition of necessary beyond the dictionary, but it becomes some showing that has to be made. You can't just say, well, there's this exception and we voted on it, so it was necessary.
Right.
Because then you don't ever have to have agendas. Just don't print an agenda and everything you do that day, because you voted on it, it was necessary.
I think that's totally fair.
But Williams was a great find. It is very useful. And I thought overall the order was great. It was a balancing thing and it's very healthy. I appreciated that you in your email said, I need to tell you, I did struggle with this. And when I first started, I wasn't going the way that I ended up, because I was the same way. I had finished my revisions and it said, you know what, we need to respect the legislative prerogative, and they voted on it. It must have been important, or they wouldn't have wasted their time voting on it.
Right.
And I was walking the dog last night and I'm thinking, you know, you can never make a claim that way then.
Yeah.
There's no point to it. So it means that I disagree with Bethel's dissent, but maybe that's why that was a one-person dissent in that case.
Right. That's true.
So, but that's all. I just wanted to let you know, I had worked on it. It was a great draft. And hopefully you will have smoother sailing going forward. These dismissals shouldn't be anything hairy like these other ones have been.
Right. Yeah. Well, it was really interesting, and it'll be interesting to see their open records claim go forward.
Yes. Yes. Part of me thought they may just drop it because the bond validation is over now. I mean, it's up on appeal, but I don't think it's going to change anything. And so what's the point? But the point may well be you can't just do what you did with your agenda, city council, and they may want to score it that way. So who knows?
Right. Let me ask you, are you going to be working from home all week? I just want to make sure I'll let the sheriff's office know.
Yeah, so no, I will be going in, and this was a switch up. I switched up on you. I was supposed to be going in this morning for this, but I got a lot of pushback at home.
Understandable.
When you got that email saying, hey, could we please put things in the afternoon now? I had to split the baby. So I will be going in on Thursday for the Interpleader. If I'm remembering correctly, that's with that angry Nigerian guy.
Right.
He may
Which,
show up. So
true.
this was one where I didn't think anyone would show up. And so it was a gamble because the nice I said, the courtroom's going to be open. But I'm going in, to answer your question, I'm going in tomorrow afternoon for criminal stuff.
Okay.
I'll be in on Wednesday afternoon for drug court. And then I'll be in Thursday morning for the Onwe Interpleader. I'll be in court. So I'll be able to sign the stuff. I saw your email that you left some stuff on my chair. I'll sign that tomorrow when I'm in. And I don't mind taking it to the clerk's office. You're welcome to if you like getting a break from home and it's an excuse to get out of the house. But I had offered to Deidre before to take things to the clerk's office. I just need to be told where to go. And
Okay, great. Yeah. Well, that's good. I don't think I need to tell the sheriff's office anything different then.
Yeah, well, they may have been there this morning and wondered what happened, but as long as they know, it's on Deidre to have let them know about the well, however you guys divided it up, the criminal stuff tomorrow, and the drug court. I don't know who tells them that, but I think the case manager for Judge Brasher lets them know about the drug court. And then as long as you told them about Thursday morning, I'll be there for that.
Yeah, I think they're planning on Tuesday, Wednesday, Thursday. So that'll be good.
Good. Excellent. So you should be getting a few emails. I was a little from the lawyers here. I was a little surprised by Van Sant. He didn't seem to want to play ball after they appeared to me to have negotiated it. That was weird. But I guess that's what lawyers do.
Right. I mean, at least they have the UIM avenue.
Yeah, I guess. And so what is that? They would be then going after the carriers for the actual victims. Is that how, I mean,
so, yeah.
So if I have, like I have Geico, if I were Mr. Morgan, I'm not at fault. This guy rear-ended me. So first I try to get money from him, and that's auto owner's insurance, but that quickly taps out. And then I guess I look to Geico for the uninsured motorist piece.
Right, but I think it's a specific add-on. So I guess you know, like Mr. Fernandez double check to see if his client had it.
Yeah. I think you have to have it in Georgia. I don't think you can have a policy without coverage, but maybe,
Okay, maybe that's right.
because hospitals were getting stuck with bills that weren't getting paid. But maybe you can get a bare bones. I don't know. I think my recollection is, and I don't do a ton of the insurance stuff, is that you have to have some, but you can have it real low and then it doesn't cost too much. You also can have it high because you're worried that someone who's uninsured or has minimal coverage does a lot of damage to you or your loved ones. Then you want high uninsured motorist coverage. But we'll see. They will pursue that, and we'll go from there. So let me know what you hear from the different lawyers, and then we can put all that into an order that gets things out.
Okay, that makes sense.
Great. We've got at 1 o'clock the surrogacy. You're welcome to dial into that. You don't need to. And that's it for today.
Okay, sounds good.
Thanks.
All right, you have a good one.
You too. Bye-bye.